Yes, I'm just getting in right now.
Okay.
All right, thank you.
Thanks. Bye-bye.
Bye.
All right, I think we have everybody connected. We'll go on the record. We've got two different files that we're hearing this matter, People versus Mark Allen Pingator, case 144923 and 144924. If I could just have both counsel put your appearances on.
Yes, thank you, Your Honor. For the record, Mike Rolla on behalf of the people.
Afternoon, Judge Elliot Blumberg on behalf of Mr. Pingator.
Right, and Mr. Pingator, are you connected? Mr. Pingator, can you hear me? Mr. Pingator, are you able to hear me? All right, Mr. Blumberg, I mean, I've got him connected. I can hear him.
Yeah, Judge, he was coming from the Upper Peninsula and the bridge was closed because of falling ice. And so he's made other arrangements. I don't know if he's in his car or whatever, but I can hear him, but I don't know if he can hear us.
It's not
I
allowing
don't think so. Do you want to try and contact him and let him know, like, he's got to do something with the settings there?
Judge,
or do you want to reschedule it? I'd be happy to do either one.
This matter was filed back in 2020. We've been waiting 4 years to get a hearing date, mostly because the Attorney General's office was a bit dilatory in getting their letter out, which we received back in August, which indicated their understanding that he was eligible for this expungement. I contacted Mr. Rolla this morning just to see if he was going to be involved in it, and apparently he has a different view of the eligibility in this matter. I don't know if we can resolve that, or do we need to reschedule it, or certainly not to speak with Mr. Rolla for him. The two matters that Mr. Pingator pled to, neither of which would disqualify him for the expungement.
I'm unmuted and I don't hear anything. I see the participants there and I can't seem to get my...
I'm just going to keep muting him because that's kind of interfering and he obviously can't hear us. But that sounds like, it sounds like we may have a legal issue here. So I think we can address that without Mr. Pingator, participating. So Mr. Rolla, what's your objection? If you have one.
Thank you, Judge. In fact, I just sent Mr. Blumberg another email. I believe Mr. Pingator is eligible in regards to file number 144923FH. That's the school failure of employee to notify. I don't think there's an issue there at all. In fact, in the facts in this particular case, the only reason the charge applied, as I understand it, is because Mr. Pingator, although he may have notified verbally either the superintendent or the principal, he didn't do so in writing until a day after he was required to do so. So I don't think there's an issue there. The problem, as I expressed to Mr. Blumberg, is actually a legislative statutory one. Under the amended version of MCL 780-621C, effective, let's see here, April 11, 2021, it states under subsection 1, a person shall not apply to have set aside, and a judge shall not set aside a conviction for any of the following. Under D, it indicates the following traffic offenses. Under D1, it says subject to subsections 3 and 4, a conviction for operating while intoxicated committed by any person, and under subsection 3, as it applies in this case, any traffic offense that causes injury or death. The fact of the matter is, in this particular case, it was a situation where a bicyclist was injured and was hit and very badly injured, to the extent that there were numerous medical procedures that had to be done that obviously caused impairment of a bodily function. And I think that unfortunately disqualifies him statutorily. Now, I don't dispute that the Secretary of State, I'm sorry, the Attorney General's office send out their letter, but as the court's well aware, they send out their generic letter, which says we believe the person may be eligible if the court finds, and then they list a whole bunch of things that the court has to find.
My response, just briefly, Judge, is that what he pled to was operating while intoxicated. It wasn't.
Yeah,
Correct.
so,
It wasn't reckless driving causing serious harm or anything like that. It was merely an OWI.
And I understand that, Judge, but the statute doesn't say pled to or sentenced on. It says that the offense specifically was any traffic offense that caused injury or death. It doesn't say as pled to or anything. It doesn't give that qualification. And I'm just telling the court what the statute says as amended. It was part of that Criminal Justice Reform Act. They don't distinguish. I tried to find some case law on it, Judge, after Mr. Blumberg sent me his stuff this morning. That I can't find anything specific that it's been addressed by our appellate courts, but that doesn't surprise me since it's a relatively new change in the statute.
Judge, does it make sense that you take this under advisement so we can research it and provide the court with the legal authority for our positions?
well, I mean, I looked at the statute prior to the hearing, and I mean, my interpretation is different than the prosecutor. So I'm looking at, which I believe is the right statute that Mr. Rolla indicated, which is MCL 780.621C sub 1, which says a person shall not apply to have set aside, and a judge shall not set aside a conviction for any of the following. And then under sub D 3, any traffic offense that causes injury or death. And so the conviction that's being sought to have set aside here is driving while intoxicated, not driving while intoxicated causing injury or serious bodily impairment. So if that was the conviction, and if Mr. Pingator had pled as charged, then I would agree with Mr. Rolla. But the conviction that he's seeking to have set aside here isn't an offense that involves injury or death. It's a driving while intoxicated. So in my view, under MCL 780.621C, he's not precluded from having this offense set aside. So to the extent that that's an objection, I would overrule that.
And Judge, if that's the court's
did you have-
position, then I believe Mr. Pingator satisfies the other conditions.
Okay. Now, Mr. Blumberg, next issue I see, it looks like Mr. Pingator has also tried to sign in under a different device, so I'm going to bring him in on that one, and let's see if that makes a difference here.
I think he's still muted, Judge.
I don't even see him.
Yeah.
Mark's phone down at the bottom.
I don't have that on.
Mark,
There he is. He's still muted, though. His face is there now.
Yeah, I don't have him on my screen for some reason. I have Mr. Fighter.
He's right next to her, Elliot.
right.
He's not on my
Mr.
screen.
Pingator, Mr. Pingator, if you can hear me, we need you to unmute, please. So you need, Mr. Pingator, you need to hit the unmute button. All right, Mr. Blumberg, I guess, I mean, I understand that we don't want to delay, but I don't know what else to do at this point, and I do have another hearing at 1:45.
And Judge, and certainly you don't want an offer of proof from me. I'm sure you're going to want to hear from Mr. Pingatore himself. At least I would assume.
Right, yeah, I think I need to make the findings I would need to make.
Yeah. So we'll just reschedule this when, and again, he left in plenty of time to get here. It's just that the bridge was closed. So, but I appreciate the court's ruling, and we'll just renotice this up for another day.
Okay, yeah, I mean, I think that's just bad luck on this part. So, okay, thank you. You're free, Mr. Roll and Mr. Blumberg, you're free to disconnect at this time.
Thank you.
I think that's, see you, Elliot.
Yeah, Mike. See ya.
Okay, Mr. Mamet, if you can unmute yourself, please.
Yes.
And then, good afternoon, thank you. And then we have somebody on an iPhone. Can you tell me your name, please?
It's Trevor Pickleman, sir.
Mr. Pickleman, okay. All right, we're on the record now in Michigan Schools and Government Credit Union versus Trevor Pickleman. This is case number 2319476. Counsel, if I could just have you put your appearance on the record, please.
Your Honor, Muggle Team Unit P811021 on behalf of plaintiff.
Thank you. And then we have Mr. Pickleman present also by Zoom. This is set here today for a pretrial scheduling conference where I would normally set some dates for going forward. Mr. Mahmoud, how did you want to proceed in terms of scheduling? Did you want to have some kind of early mediation or some negotiations with Mr. Pickleman, or how did you want to go forward?
Your Honor, after reviewing the defendant's answer, the only real dispute he has is he doesn't believe that the car was sold at auction for a reasonable value, but an auction is considered a commercially reasonable way to, sell the vehicle in this situation. So I think the only real dispute there is the amount at this point. Would it be possible for me to get into a breakout room with the defendant just for a few minutes, just to see if we might be able to wrap this up this afternoon for you, but
All right, Mr. Pickleman, do you have any objection to having a discussion with Mr. Mahmoud privately in a breakout?
No, I don't. But also, I just wanted to also say that in my answer to that, I tried to settle this personally with Michigan Schools and Government this summer, actually in July. I gave them, they said, what price would you be able to 100% for sure afford and pay? And I gave them two options. I said, as of the moment right now, I can pay you $500, but I can guarantee you $100 because stuff slows down later in the year per what I do for a line of work. And they denied both of my claims for what was affordable for me and my family, being the sole provider, having two kids and a fiance that stays at home.
All right, well, I'm going to have you talk to Mr. Mahmoud about that in the breakout room, and once you guys are done, it'll automatically kick you back in. I may be in the middle of another hearing, Mr. Mahmoud, but I'll get back to you guys as soon as I can once you're done.
not a problem. Thank you, Judge.
Okay, I'm going to open up that breakout room right now. It'll take 1 second. All right, sir, can you tell me your name, please?
Adam Pearl.
Mr. Pearl, okay. Okay, ma'am, I just need you to unmute, please. All right, can you tell me your name?
Susan Pearl.
Okay, we're on the record now in Pearl versus Pearl, case number 2319501. The record should reflect both parties are present today by Zoom video. This is set today for entry of a default judgment of divorce. Mr. Pearl, it looks like you were served with the complaint back on November 13th. You did not file an answer, so you were defaulted in this case. And Ms. Pearl, did you want to proceed with entry of the judgment of divorce today?
Yes.
Okay. So Mr. Pearl, I don't know if you want to try to contest this or not, but since you've been defaulted, you would have to file a motion to have that default set aside, okay?
Okay, it's all good.
All right. So Ms. Pearl, I'm going to put you under oath, and I've got some questions that I need to ask you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
Okay.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. You can lower your hand. Ms. Pearl, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving or paying any spousal support or alimony. Do you understand that?
Yes.
That means that you would not be able to come back later and ask the court for that and that you would be waiving that forever. Do you understand that?
Yes.
Okay, and under this judgment, you and Mr. Pearl would keep whatever property was in your own possession and you would be responsible for any debts that are in your own name. Is that correct?
Correct.
And you don't own any real estate or real property together?
No.
Okay. All right. Mr. Pearl, from your standpoint, are there any issues with the testimony that Ms. Pearl has given here today?
No.
Okay. And Ms. Pearl, you're asking to have your last name changed, is that correct?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Pearl. The court will grant the divorce and I'm signing that judgment, so the divorce will be final today. Ms. Pearl, that means that your last name is legally changed from today forward. So you'll want to contact the clerk's office to get a copy of this judgment because you'll need that for changing your identification and other documents, okay?
Okay.
Ms. Pearl, did you have any questions at all?
No,
No.
no questions. No.
Mr. Pearl, did you have any questions at all?
No, I had no questions.
Okay, and Mr. Pearl, you can also get a copy of this at the clerk's office if you'd like that for your records as well, okay?
Thank you.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
Well, hello.
Okay, are we ready to go back on the record?
Yes, Judge.
Yes, sir.
Oh, all right. Okay, we're back on the record in Michigan Schools and Government versus Pickleman. As representative for plaintiff, Mr. Mahmood, I'll ask you first. Where are we at?
Your Honor, again, Michael T. Mann, PA1102 on behalf of plaintiff. Your Honor, we were unable to come to an agreement while in the breakout room. I do think we can get it done. I know the court mentioned mediation or another ADR before we went into the breakout room. I don't think it's necessary in this case, but I would suggest if the court would be willing, 75 days discovery and then just a motion date after that, or even at the end of discovery, if we could have a final pretrial just to see where we're at that point before I have to file a dispositive motion, I would appreciate it.
Okay. All right, Mr. Pickleman, was there anything that you wanted to request regarding dates for scheduling as we go forward?
No, Your Honor.
Okay, so here's what we'll do. I'm going to leave discovery open for 90 days, and then the court will set a dispositive motion cutoff at that 90-day mark. Mr. Mahmood, we would need to have any motions filed. They wouldn't necessarily need to be heard by that 90-day mark, but we need to have them filed by then with the hearing date. And then let's see what, if any, claims remain after that, and then we can do further scheduling or talk about ADR, which Mr. Pickleman, that is mediation or other ways of settling the case outside of the court making rulings. And we can consider that at that time. Obviously, the two of you are free to continue to negotiate as we go forward over the next 90 days as well to try to reach an agreement. Any other dates, Mr. Mahmood, that I can address for you today?
Again, Your Honor, would the court be amenable to a final pretrial in between the end of discovery and a dispositive motion date?
Sure. Yeah. I mean, you want me to set like a status conference at like 60 days?
Oh, no, after the end of discovery, but before the MSD date would be heard. I mean, you know what, we can do 60 days, however the court would like to do it. I just like to communicate as much as I can with the defendant before I need to, do what I need to do on that dispositive motion. I like to try as much as I can.
All right, understood. So let's do this. We'll leave discovery open for 90 days. I'll set it for a status conference at that 90-day mark, and then the dispositive motion cutoff will be 120 days.
All right. Thank you, Judge. I appreciate that.
Okay. Mr. Pickleman, did you have any questions or concerns?
No, Your Honor. I think I'm okay.
All right. The court will set out a notice of the date and time for that status conference at about 90 days. And that'll be by Zoom as we're doing today. That's all I have, and all parties are free to disconnect at this time.
Thank you, Judge. Sir. In addition to the notice, will the court be sending the entire scheduling order?
Yes. Yeah.
All right, perfect. Thanks, Judge. I appreciate it.
Thank you.
You guys have a good day.
Thank you. All right, looks like we've got everybody. Mr. Conklin's signing in, so let's just make sure we get him in here. I think Mr. Conklin might be having some connection problems because he was here and then he left. So if you guys can just hold tight here for a second.
Sure.
It better be water.
It is, Dave. It
All
is.
right. Just making sure.
There we go.
Sorry about that,
All
Your
right,
Honor.
I think we get, that's okay. All right, we're on the record now in IRT Commercial Services versus Cash and Carry Flooring, case number 2218977. And if I could just have counsel put your appearances on, please.
You're muted, Dave.
Everybody's on mute.
I'm sorry. David Svengros on behalf of Westwind and Gaylord.
Richard Conklin, on behalf of SRS Commercial Distributions, DBA Willoughby Supply.
Your Honor, Greg Light here on behalf of Chris and Margaret Lee.
All right, thank you. We're on the record today for status conference, but also for motion hearing. So I'd like to address that first. Mr. Svengros, this is your motion for partial summary disposition as to the unjust enrichment claim of Willoughby. Is that correct?
Correct, Your Honor.
Okay. I did have a chance to review your brief and the attachments. And Mr. Conklin, I got the response brief from your side. I had a chance to review that as well as the attachments as well. Mr. Svengros, anything by way of oral argument in support of your motion?
Your Honor, I think I submitted a reply also, but so I'll be really brief. There's one count remaining against Westwind, and it's an unjust enrichment quantum Merowith claim. And our motion is based upon a couple of factors. The first being the existence of an express contract governing the subject matter, which is the outstanding amounts due to Willoughby. We believe that the existence of a express contract involving the same parties bars legally any claim for unjust enrichment. And I think that contract also covers the quantum Merowith unjust enrichment claim because, as the court recollects, the elements of a quantum Merowith claim include some type of unjust action by Westwind. And I think in the contract itself, it states that Westwind has paid in full. So not only does that eliminate the adjustment claim, but I think it shows that, that Westwind has done everything they were supposed to do under the contract. So, courts will not imply a contract where there is a written contract covering the same topic, and an adjustment claim must show some wrongful act by Westwind. And they didn't sue us on a breach of contract claim. They haven't sued us for breaching the settlement agreement. In fact, we complied with that settlement agreement. Westwind is the only party who's complied with all of the settlement agreements. And then on a related issue, if you look at that settlement agreement, it provides for Willoughby to get recovery from the individuals for IRT, including Mr. Light's clients. And I believe Willoughby has resolved their claims against Mr. Light's clients by payment of some amount. I don't think it's the full amount, but it's payment of some amount. And that hasn't been, I believe, brought to the court's attention. But I think in any event, we have a situation where an unjust enrichment claim is just not tenable under the circumstances, be they legally or factually, and therefore that's why we're requesting summary disposition today, Your Honor.
All right, thank you. Mr. Conklin?
Your Honor, I know you've read the briefs regarding Westwind's partial motion for summary disposition of count 2 of Willoughby's cross claim. I'd like to address just 3 main points in our brief in opposition as to why the court should deny Westwind's C8 and C10 motion. First, I'd like to point out that Willoughby Supply still has 2 counts remaining, Quantum Merriwood against Westwind and Quantum Merriwood against Gaylord. Opposing counsel appears to kind of be conflating the parties and the issues a little bit at bar. The current motion does not involve Gaylord Apartments or count 3 of cross plaintiff's claims. Secondly, the C8 motion is tested on pleadings alone and are taken as true. And in this case, examining cross plaintiff's claims just in the light of the most favorable to the non-moving party, which is the cross plaintiffs. This shows that the claim of Quantum Merriwood against Westwind is true and enforceable for the purposes of determining this motion, which is just whether there is a well-pled complaint. Westwind's argument conflates the standards for C8 and C10 as they argue the existence of the settlement agreement should also be examined, but the settlement agreement is not part of the pleadings as defined by the court rules for C8 standard, and therefore should not be considered when reviewing the pleadings. Third, and lastly, regarding Westwind's C10 motion, this court in its September 5th hearing denied Westwind's request for summary disposition pursuant to a C10 standard and ruled that the settlement agreement created a genuine material fact. Since no additional facts or evidence have been presented in this matter since the hearing, this court should continue to uphold its previous decisions. And therefore, we respectfully request that this honorable court deny Westwind's motion for summary disposition to pursuant to MCR 2.116 C8 and C10 and find that Willoughby's Supply's claim of Quantum Merriwood against Westwind as set forth in count 2 is valid and that a genuine question of material fact exists. Thank you.
All right, thank you. Mr. Light, did you want to weigh in either way on this? I know I don't think you submitted any kind of response or jumped in on this in writing.
I did not, Your Honor, and I have no input. Thank you.
All right, thank you. And Mr. Stengross, I did not receive your reply brief. I mean, I'm sure it was provided. I may just not have had a chance to get it and review it prior to the hearing today. So is there anything you wanted to say in response to Mr. Conklin's arguments on the record?
Well, my reply was pretty short and pretty much was exactly what I said, but I guess I don't know what Mr. Conklin is actually saying. Is he denying the existence of a settlement agreement that has been submitted to the court on multiple occasions, signed by his party, and now saying that it doesn't exist? I guess I don't know what that argument is, but I would say as far as C8 is concerned, the existence of that document, though not pled, should have been pled and is before the court and has been submitted through discovery. So the existence of that document is what I'm saying bars a claim for the court to apply a contract governing the payment of the amounts due to Willoughby, if any. And then factually, the existence of that agreement, I submitted it to the court. It's included as part of the pleadings. They don't deny the existence of it. And factually, it says that Westwind did nothing wrong. They haven't pled that they breached that agreement. And therefore, under a C8, legally, there's no claim given the existence of the settlement agreement. And factually, there can be no development and as far as I know, Willoughby hasn't come forward with any development that shows that Westman did anything wrong to create an unjust enrichment claim, which, as the court noted in the transcript, which was submitted by Mr. Conklin, there's a requirement that Westwind do something wrong. They didn't. They paid in full. And that fact is acknowledged by Mr. Conklin's client. And therefore, under C8 or C10, I believe the court has sufficient grounds to dismiss the unjust enrichment claim. And, you know, I did have the opportunity to review Mr. Conklin's written brief, and there's a lot of discussion regarding a lien. The lien issues are irrelevant for various reasons, but mainly because the court has dismissed that lien claim. So all they have is an unjust enrichment claim to recover against Westwood. And, you know, based upon the facts and legally, there really is no claim at this point, and this matter should just go away.
All right, Mr. Conklin, anything further that you wanted to add?
Yes, Your Honor. Just one last thing. The settlement agreement exists. I think the opposing counsel's argument kind of begs the question, since the settlement agreement creates a question of what exactly the settlement agreement purports to be doing between the three parties, Westwind, Willoughby, and IRT. So I think there is a huge genuine question of material fact that exists here because of what this settlement agreement purports to be doing. Additionally, the settlement agreement, the court rules suggest that it should not be considered when viewed with a C8 standard. It was not part of the pleadings as per the definition of the court rules. Thank you.
All right, thank you. Okay, I did have a chance again to review the written submissions of the parties. I was kind of already familiar with the facts and the posture of this case based on some previous motion hearings that the parties have referenced here today. Looking at Westwind's motion here, which is brought pursuant to C8 and C10, I think both sides correctly stated the standard that the court has to look at under both of those court rules. And frankly, in my view, this is more of a C10 motion anyway than it is a C8 motion, which I'll explain in a moment. But I would adopt both sides' recitation of the standard of review by the court for a C10 motion, which is that there is no viewing all the evidence in a light most favorable to the non-moving party. There's no genuine issue of material fact, and that the moving party is entitled to judgment as a matter of law. And I think the settlement agreement is obviously a key factor here. And I agree with Westwind's statement of the law in that where there is an express contract, the court should not and cannot imply a contract. And so I think the real question here is whether or not there's any question of fact that the settlement agreement represents an express contract between the same parties involving the same subject matter as what's being claimed by Willoughby in their claim for unjust enrichment. And so looking at that settlement agreement, going to the language of that agreement, which was entered into in January of 2022, at the time that was entered into, it's my view that the evidence pretty clearly shows that Willoughby was aware, number one, that Westwind had paid IRT all the money that was owed, that IRT still owed Willoughby somewhere in the neighborhood of $284,000. And in that settlement agreement, Willoughby essentially agreed to take $40,000 in cash from Westwind to accept payments from IRT and Lee and Collins, and then that consent judgment, that pocket judgment against Lee and Collins if they defaulted. And that settlement agreement also provides that it was resolving all the disputes at the time existing between parties. So, I mean, to me, that settlement agreement really becomes the touchstone here of how everybody's going to go forward from that point. And again, Willoughby went into that and entered into that agreement knowing all of those facts. And so in my view, there really is no question of fact that, number one, that's an enforceable contract as a settlement agreement between Westwind and Willoughby, and that Willoughby essentially gave up any claims it might have against Westwind in entering into that settlement agreement up to that point. So in my view, for the court to allow Willoughby to now, it looks to me like an unjust enrichment claim here is kind of an attempt to go around that settlement agreement and get Westwind back on the hook for what that settlement agreement put IRT and Lee and Collins on the hook for. And so in my view, we do have an express contract that covers the same subject matter. It's between the same parties. And I think that everybody's stuck with that settlement agreement, and that, again, I think based on the existence of that, Willoughby can't kind of get around that by filing a quantum meruit or unjust enrichment claim. So the court finds that there is no question of fact, that is the agreement that controls, and that precludes a claim for unjust enrichment by Willoughby at this point. And so the court finds that and I think this is a different question than what we addressed at the previous hearing in terms of that settlement agreement and whether or not there was sufficient evidence to show wrongdoing on the part of Westwind to sustain an unjust enrichment claim. I think what we're dealing with here is a different argument by Westwind that points more towards the existence of that settlement agreement as an express contract that would preclude the unjust enrichment claim, as opposed to although Mr. Snegros has sort of argued it today that there's no question of fact that there was no wrongdoing. I think it really goes back to that agreement as an express contract that precludes the unjust enrichment claim. So I think it is a different question. It's postured differently in this motion than it was in the previous hearing. And I don't think it's inconsistent for the court to have found that there's a question of fact about whether Westwind acted improperly, but not a question of fact that settlement agreement represents an express contract that would preclude the unjust enrichment claim. So I don't find those are inconsistent rulings. They're rulings on different aspects of that claim and different arguments. So for those reasons, the court finds that Westwind's motion should be granted. And Mr. Snegros, I would ask that you submit an order under the 7-day rule reflecting the ruling of the court today.
I will do that.
And then I don't know, frankly, what that leaves us with. Just looking at my diagram of the claims and counterclaims here, does Westwind still have a claim against Collins and Lee as part of this litigation?
Not, I believe the claim between Mr. Light's clients and my client exists. There's nothing with Collins anymore. So the only thing I would say to that is, if the court would grant us a little bit of time, maybe 30 days, to see if we can get to the bottom of our claims and get those off the docket.
I'd support that, Your Honor.
Okay, Mr. Conklin, do you have any objection to that?
Not at all, Your Honor.
Okay, so I'll set this for a status conference in about 30 days. We'll do that by Zoom, and then let's see where everything shakes out after the hearing today.
Thank you, Your Honor.
Okay, thank you. That's all I have. All parties are free. Yes, Mr. Conklin.
We still have one count remaining against Gaylord Apartment Fund for quantum meruit.
Your Honor, there was a combined motion for both parties. That's been the case.
Yeah, I mean, I think I agree with Mr. Stenger. I mean, I think that resolves the claim against both sides here.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. That's all for today. All parties are free to disconnect at this time. All right, Mr. Jones, are you able to hear me okay?
Yes.
And Ms. Jones, are you able to hear me okay?
Yes, sir.
Okay, we're on the record now in Jones versus Jones. This is case number 1917709. The record should reflect both parties are present today by Zoom video. Ms. Jones, this is your motion to enforce the judgment of divorce. And if I read your motion correctly, you're indicating that the real property still hasn't been refinanced as required under the judgment. Is that the problem?
That is correct. And he's also making the mortgage payments, but they've been late for 5 months, which is affecting my credit.
Okay, all right, thank you. Mr. Jones, what's your side of this?
The mortgage payments are caught up at this point. They're current. They have been late for 5 months. I can give you a list of reasons why that is the case. The main one is that Mrs. Jones filed a false police report saying that I broke into her home and that she had video footage of that. She then left town and told the police she would get them the video footage after the holiday weekend. They essentially raided my work, went through all the cameras, interviewed all my coworkers, and I am not employed by the facility. I'm employed by a contract company that is hired by the facility, and the facility didn't like that very much, so they fired me. So I'm now waiting tables with a master's degree and 2 bachelor's degrees because and Mrs. Jones called on Monday and said she couldn't come up with the footage and that she wanted to drop the charges. The officer in charge of the case is even at the time is considering asking the prosecutor if they will swear out a warrant for the video that Miss Jones says she has, because she did file a false police report. And at that point, they're looking to go after her for filing false police report because of this. But that hiccup cost me a lot of money and time. I've now secured other employment, but like I said, I'm waiting tables. I'm making up enough money to pay the mortgage. I've caught the mortgage up completely, and it is current through now. And I believe I'm making enough money currently to continue to pay the mortgage on time. And I don't foresee any problems. But again, these are problems she's bringing on herself. That, in addition to that, having not seen her children in 4 years when I pay child support based on 50-50 custody, but she has nothing to do with the kids. And I'm bearing all the expenses of child support to her. And again, raising both children who now both have driver's licenses, who both need car insurance, who I'm making it all work, but losing my job made it very difficult to pay the mortgage and made it difficult to catch up while trying to find employment. And like I said, I'm waiting tables.
All right, thank you. Ms. Jones, anything you wanted to say in response to that?
Well, there was incidents that did happen over Thanksgiving, so that was the end of November. The payments that they started missing out was from September, which I provided for documentation on that. The kids, Mr. Jones has had multiple jobs. He's been bartending and waiting on tables while he was still doing his therapy work also. So this whole time he should have had enough money. Plus he has one of our son's friends paying him rent.
Not true. Never has been true.
Okay, Mr. Jones, it's Ms. Jones' turn to talk. You had a chance, so I'm gonna hear from her now, all right?
Yes, Your Honor, I apologize.
The agreement on the divorce was that he wanted to keep the house. Part of that agreement is that he makes the payments on time. It's going on 4 years. It'll be 4 years in April. He's making it work. He cannot refinance at this time because of his late payments of 5 months, not just a couple of months. It's been 5 months. And he still has not paid for February. So I just don't see a solution to this other than the court helping him to make the payments on time so that does not affect my credit, since he's not going to be able to refinance for who knows how long.
All right, so we've been dealing with this issue for a long time. I have no idea what the actual circumstances are getting two sides as to what recently happened. Mr. Jones, for you to lose your employment. But this judgment was entered into in April of 2020. And you still haven't refinanced the house. And under the judgment of the divorce, it says that the defendant shall commence the refinance of the marital home into his individual name within 7 days of entry of the judgment of divorce, and is required to continue the refinance process in good faith thereafter. Should plaintiff have to cause to bring enforcement motion before the court, she shall be entitled to reimbursement of costs and reasonable attorney fees. Defendant shall hold plaintiff harmless from any liability and indebtedness for the real property at home. So, Mr. Jones, this judgment puts that responsibility squarely on you. And it's almost 4 years now and you still haven't refinanced the home. Ms. Jones, as I've indicated to you in the past, I can't force a bank to give Mr. Jones a loan. All I can do is require that he continue to try to refinance the property. And so, Mr. Jones, you're going to have 30 days from today's date to provide the court with documentation of at least 3 attempts to refinance the home, 3 different financial institutions. And you need to provide documentation from the financial institution itself, not something from you, indicating whether or not they've been able to refinance. And Ms. Jones, because Mr. Jones is responsible for refinancing it, and because he hasn't done that, I mean, if you have some kind of tangible damages from that's resulted to your credit from him not making the payments and not refinancing, then you may be entitled to those damages, but you would have to submit to the court some documentary evidence of that, whatever those amounts might be. So to the extent that you would like to seek that, I'll ask you to submit that to the court, and then the court's going to set this for another hearing, and we'll see where we're at that point. Ms. Jones, questions about that?
Well, since he's been past due for 5 months, I don't see him being able to be refinanced. And since we're going 4 years, is there going to be a way for me to get a time frame put onto this? Where, I mean, I don't know how much longer this has to go on.
Yeah, you know, unfortunately, the divorce agreement that you guys, I mean, I just read what the divorce agreement says, and unless the two of you come up with some other type of agreement or some other type of arrangement, that's what I can enforce, and that's what I can do. So the document that you guys drafted up is what I have to follow, just as it is what you guys have to follow, and it limits me in terms of what I can do to make this go forward. So that's all I can do, is really require Mr. Jones to continue to attempt to refinance the home in good faith, just as the language of the judgment says. But the language also says that he has to hold you harmless for any liability or indebtedness for that property. So again, to the extent that you're incurring some type of financial damages, then he's going to be responsible for those. But I have to have documentation of that.
Okay.
All right, Mr. Jones, do you have any questions?
I don't have any questions. I just wanted to point out that I am absolutely following the judgment of divorce I mean, as far as I know. If that's not the case, I would like for you to tell me so that I can do something differently, or, you know, whatever the case may be. We knew that this was going to be difficult. That's why it's written like that. Neither of us wanted the house. We attempted to sell the house. I have put a new roof, new appliances, new flooring. I've put all kinds of stuff into this house because it's falling apart, and I'm taking up for her financial responsibility. Neither of us, like I said, neither of us wanted the house. I took the house because I was the only one that could afford the payment, and obviously that became difficult lately, and it's the reason I haven't refinanced. But these are all things. This is a contract that Miss Jones entered into, and I am now fulfilling.
I don't know why I'm being looked at as the bad guy or having done something wrong when I'm doing everything I can. Like she said, including working 2 jobs. I've now picked up another job waiting tables. I'm working 2 separate places doing that now because I've lost my other job. I mean, I am bending over backwards and just busting my butt to try to get this done and honor our agreement. And I believe I'm doing so. I just, in good faith, I'm continuing to attempt to refinance, but I haven't been able to as of yet.
Yeah, so I mean, the only reason why we're here is because you haven't refinanced the home. So when you ask me what you haven't done, that's what you haven't done. If you refinance the home or sell it, do something with it, I don't know, but that's why we're here. So if you want to know why we're here, I read you what the judgment says. We're here because you haven't refinanced the home yet. So
The judgment, of course, doesn't say I have to refinance the home. It says I have to begin within 7 days and continue to attempt in good faith to refinance. And that's what I'm doing. I want to. I don't want this. This is, I mean, nobody would want this.
then keep trying to refinance the home then. And that's what I'm making you do is
Yes,
give me proof that you're trying to refinance the home. I think it's pretty obvious. And I think if you look at this with some common sense, trying to refinance the home ultimately results in refinancing the home, right?
If you have a credit score to do so, yeah, absolutely. But I just
you know, you entered into this agreement too. Your signature's on this document. And so if you didn't think you were going to be able to do it, you shouldn't have signed it either. You should have come up with a different plan. So you're equally, both of you, at fault for entering into agreement that's not working out for either of you. But that's what you have and that's what you're stuck with. And so when you ask me what you need to do, that's what you need to do.
okay, I'll get 3 letters from 3 companies.
Believe me,
No problem.
Believe me, last thing I want to do is have to keep having hearings with you. I'm only here because you guys aren't doing what you're supposed to do under the agreement. So refinance it, sell it, and you'll never have to come back to court on this case again. It's as simple as that. But until then, we'll keep seeing each other. The other thing, Mr. Jones, is you need to be more respectful with my staff when you're dealing with them over the phone. My assistant Jennifer has nothing to do with this case or the way the court rules. She does what I ask her to do. So you need to be more respectful and polite to her. She doesn't deserve to take verbal abuse from you on the phone or to be hung up on. So don't give me excuses. I don't want to. Just be polite, okay? Act like an adult when you're dealing with my staff. That's all in that.
When they start doing their job, I'll be less critical of them. But she was very delinquent in her duties.
Okay,
but
let me tell you something. Let me tell you something. Do not go there. Do not go there. Jennifer is absolutely the most conscientious employee I've ever seen. You are the one who's being rude to her. She's doing her job. You're the problem on that end, and you need to be more respectful to her. And that's all I'm going to say on that. But don't act like she isn't doing what she needs to do, because that's not true. And you know it. Don't even go down that road. Just be polite, act like an adult, and do what you're supposed to do. That's all you got to do. It's very simple. That's all I have for today. All parties are free to disconnect at this time.
Thank you.
Good afternoon, Your Honor.
Good afternoon. All right, looks like we have everybody connected. We're on the record now in Cruz versus Cruz. This is case number 2319351. If I could just have both counsel put your appearances on, please.
Good afternoon, Judge Elliot Blumberg on behalf of the plaintiff, Danny Cruz.
And Kathleen Conklin on behalf of Terry Cruz, who is the defendant.
All right, and looks like both sides are connected by Zoom as well. We're on the record today for a status conference. And let's see, Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at right now?
Sure, Judge. The parties have successfully mediated this case. All of the issues have been resolved. I will be in the process of drafting a consent judgment of divorce.
Okay, Ms. Conklin, is that accurate from your side?
Yes, that is. We have resolved the matter in mediation. The one thing I did need to double check on, though, is the, and Mr. Bloomberg maybe himself too, is the specific instrument that we might need to have drafted for part of his military pension.
Okay.
That's correct.
All right. Did we want to take proofs today then?
I didn't anticipate doing that. My client's in the Middle East right now, so we figured when the judgment's ready to be entered, we can just have a hearing to take the proofs at that time.
Okay, any objection to that, Ms. Conklin?
No, I don't have any objection to that. I thought maybe we could take proofs today, just get those over with, but if that's how Mr. Cruz prefers doing it, that's fine.
All right, Mr. Blumberg, 30 days, is that going to be enough time to be ready to do that?
Absolutely.
Okay. Ms. Conklin, will you be good to go at that point?
Yes.
Okay, so we'll set this for a final hearing in about 30 days. Mr. Blumberg, anything else I can address for your side today?
No, Judge, thank you.
Ms. Conklin?
That takes care of it, Your Honor. Thank you.
Okay, all right, thank you. That's all for today. All parties are free to disconnect at this time.
Thank you very much.
Judge, did you call the Crowell case? I know that got delayed because of some family emergency I had, but did you call that already?
No, but I'm getting ready to. I think we did reset that for 3:15, and I see Mr. Dundon is joining in.
Okay.
Are you ready at that one?
Yes, we are.
Okay. Okay, we've got everybody connected on Crowell versus Crowell. This is case number 2319376. And if I could just have counsel put your appearances on.
Again, Elliot Blumberg on behalf of the plaintiff, Melanie Crowell, who's appearing via Zoom from my office.
Mark Dundon appearing on behalf of defendant, Mr. Crowell, Todd Crowell, who is appearing from my office as well.
Okay, we're set for a status conference in this case today. Mr. Blumberg, can you tell me where we're at here?
Yes, Judge. Again, I think the parties have resolved all of the issues in this matter. I'm in the process of drafting a consent judgment. Once it's prepared and signed and approved, we would ask the court to take the proofs at that time and the case can be closed.
Okay, and would 30 days be enough for that to be accomplished?
Yes, it would.
Mr. Dundon?
That should work, Your Honor. Thanks.
Okay. Mr. Blumberg, anything else that we can address for your side today?
Not today, Judge. Thank you.
Mr. Dundon?
No, thank you.
Okay, thank you. That's all for today, and all parties on this case are free to disconnect at this time.
Thank you.
All right, Ms. Jennings, are you able to hear me okay?
Yes. Yes. Let's bring you up here.
Okay, we're on the record in Cheryl Jennings Wolford versus Lenford Wolford. This is case number 2319324. The record should reflect that Ms. Jennings is present today by Zoom video. This matter was set for 3:30. It's now 3:35. Mr. Wolford has not appeared today. Ms. Jennings, I have this set for entry of a default judgment of divorce today. Is that how you wanted to go forward?
Yes.
Okay. It looks like Mr. Wolford was properly served with the summons and complaint in this matter, and that he failed to answer that. Default was entered against him, and he was provided with notice of the date and time of today's hearing. Again, he's not appeared to contest the divorce. So, Ms. Jennings, I'm going to place you under oath. I've got a few questions that I need to ask you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Jennings, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Yes.
Have you been a resident of Otsego County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving or paying any spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, I understand.
Okay, and you and Mr. Wolford are going to divide up any assets or debts according to what you filled out on this proposed judgment. Is that correct?
Yes, it is.
Okay. And from your standpoint, are there any issues remaining that need to be decided by the court in the terms of the division of any assets or debts?
I need something formal from the court about the house. Just saying that will be mine.
Okay, let me take a look
He
here.
signed off on the title when he left.
Okay.
So
that's at the 136 Fallow property?
yes.
Okay, so the judgment of divorce is going to be that document. It provides on page 3 that the property is awarded to you. And so that should be all that you need.
Okay, great.
All right, so the court finds that the statutory grounds for divorce have been met. The court will grant the divorce. And so I've signed that. So the divorce is final as of today, Ms. Jennings. So you may want to get a copy of this from the clerk's office here. So in case you need it for those kind of records, okay?
Right. Thank you so very much.
All right, did you have any other questions?
No, I don't think so.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Thank you. Ms. Brown, I don't know if you can hear me, but I need you to unmute and turn your camera on, please.
Can you hear me?
I can, thank you. Are you Roberta Brown?
Yes, sir.
Okay, we're on the record in Brown versus Brown. This is case number 2319448. The record should reflect Ms. Brown is present today by Zoom video. Mr. Brown is not present. This hearing was scheduled for 3:30. It's now 3:40. Ms. Brown, I have this as a final hearing to enter a judgment of divorce today. Is that how you wanted to proceed?
Yes, please.
Okay, and I see that Mr. Brown has signed the proposed judgment, so we can go forward today.
Okay.
I'm going to have you raise your right hand and I'll swear you in. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Brown, I'm going to ask you some questions. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law.
Okay.
And my first question is, at the time that you filed the complaint in this matter, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this judgment of divorce, you would not be receiving any spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And this judgment will provide that you and Mr. Brown will keep whatever personal property you have in your own possession, and that you don't own any real property or real estate together. Is that true?
Correct.
Are you asking to have your last name changed?
No.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Brown. The court will grant the divorce. I've signed that judgment. So your divorce is now final, Ms. Brown. If you would like a copy of that judgment for your records, you can get that here at the clerk's office in Gaylord.
Okay.
Do you have any questions at all?
No, thank you.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, looks like we have counsel connected. We'll go on the record in Lester versus Lester. This is case number 2319497. If I could just have counsel put your appearances on, please.
Good afternoon, Your Honor. Travis Grote on behalf of the plaintiff, James Lester.
Good afternoon, Your Honor. Mark Dundon on behalf of Ms. Lester, defendant.
Okay, this is set for a scheduling conference in this case today. Mr. Grote, on behalf of plaintiff, can you give me an idea of where things are at so far and what you'd like to see for scheduling going forward?
Yes, Your Honor, we have exchanged the verified financial information forms. Mr. Dundon and I have started communicating. We're hopeful that we'll be able to resolve the case without any formal mediation needed and also without any trial set. So I would ask that you give us perhaps 60 days of discovery and then allow us to come back for a status conference and or a pro-con with you.
Okay, thank you. Mr. Dundon?
I agree that 60 days of discovery and then hope that works for us.
Okay. All right, then I'll just put in the order that discovery is to remain open for 60 days. And then at about 60 days, we'll set it for a status conference pro-con. The parties that have been able to resolve it will use that time to take proofs and enter the judgment. And if not, then we can talk about further scheduling. Mr. Grote, anything else I can address for your side today?
No, Your Honor. Thank you very much.
Mr. Dundon?
No, thank you, Your Honor.
Okay, thank you. That's all for today. And both sides are free to disconnect at this time.
Thank you.
Thank you.
All right, Mr. Wendling, are you able to hear me okay?
I am. Thank you, Your Honor. Good afternoon.
Good afternoon. We're on the record now in the Village of Vanderbilt versus Victoria Allen. This is case number 2319495. Mr. Wendling's here on behalf of plaintiff Village of Vanderbilt. This is a scheduling hearing. It was set for 4 o'clock. It's now about 4:05 according to my clock. I don't see Miss Allen joining in. I had this set as a pretrial scheduling conference. Mr. Wendling, can you tell me where things are at right now?
I think I can, Your Honor. I'm surprised that Miss Allen's, didn't show up for the hearing, but be that as it may, I do know that she's consulting with attorney Paul Slough regarding this. I asked Mr. Slough whether he'd file an appearance. He said he's trying to keep his expenses down, but I've known Mr. Slough for quite a while, and he is doing a pretty good job at issue. And we just received a survey in today. Has to do in part with the location of the sidewalk, whether it's within the platted right-of-way of the plat within the village or whether it's on the defendant's property, something that wasn't completely known. It was presumed from a GIS map that it was. In any event, I believe, regardless, that we're going to be able to work this out. So what I'm going to do is request of this court if we could move this by 30 or 45 days, the scheduling conference, and then go from there. And hopefully this matter will be dismissed. And by way of explanation, it's an unusual case to bring before the circuit court. Normally you have an ordinance for obstructing the sidewalk that would have some language in that effect, and we'd be in front of the district court judge. But given the nature of this plat, things that are actually missing from this plat, which is a 19th century plat, and the surveying and other information, I thought it best to bring this in circuit court. But again, I think we're going to be able to resolve this. So I respectfully request the court to adjourn this pretrial hearing for a date to be set by this court, either in 30 or 45 days, preferably after, just because I'll be out of town during the week of March 9th through the 15th. Otherwise, I'm around. So.
Okay. All right. That makes sense based on the claim here and given that we may have counsel for Miss Allen involved as well. So most likely going to set it about 60 days out. If there is a resolution before then, obviously, then we can just remove that from the calendar.
Great. Yes, Your Honor. Thank you.
Okay, anything else that we needed to address for the record today?
Not that I'm aware of. No, Your Honor. Thank you.
Okay, thank you. I will put that in an order and send that out along with the date for that status conference. And you're free to disconnect. Thank you.
Okay, thank you.
That concludes our docket for the afternoon. And Susie, I got to run right down to the office, so I'm going to bring all right, that concludes the court's docket for the day. The court will be